Alpha Day, the Committee on General Government Operation, Appropriation, and Housing is now called to order. Today is Tuesday, September 29th. The time now is 9:02. Welcome to everyone connected by Zoom and to those tuning in via television or the YouTube channel. Thank you for your patience in accommodating this Zoom platform while we maintain health emergency physical distancing mandates. Notices for this joint public or for this public hearing were disseminated via email to all senators and all main media broadcasting outlets on Tuesday, September 22nd, and on September 24th, which is Thursday. General rules of of this meeting. This hearing, the Zoom meeting is hosted by my staff and will mute all Zoom participants until called upon by myself. Members of the committee and or legislature wishing to speak may indicate their desire to the chair through the in-app chat feature. Individuals testifying shall first be recognized by myself before speaking and begin by stating your name for record-keeping purposes. When called to speak, please ensure that you are unmuted. Committee members will be allowed to pose a question to an individual testifying, and if needed, we'll have another round of questions. Questions and testimonies shall be confined to the substance or nature of the agenda, which is we're discussing two of the bills of Senator that was authored by Senator Mary Torres. Personal inference as to the character or the motive of any senator or any individual testifying is not permitted. Any violation of the general rule of conduct will be result in removal from the public hearing by the host. Please ensure that your video remains on throughout the hearing. Participants must be visible at all times and not engage in other activity during the hearing. Failure to maintain visibility may cause your removal from the meeting live stream. If you need to take a drink, just feel free to have, drink. All right, we'll be discussing Bill 369-35 COR, introduced by Senator Mary Camacho Torres, an act to add a new Article 10 to Chapter 33 of Title 5, Guam Code annotated, relative to authorizing the performance of notarial acts by remote online notary public, and to further add a new Article 11 to Chapter 33 of Title 5, Guam Code annotated, relative to authorizing the recording of an electronic record, and to amend Section 33512 of Chapter 33, Title 5, Guam Code annotated, relative to criminal prosecution of a notary office, and to add a new Chapter 3 to Title 31, Guam Administrative Rules and Regulations relative to implementing rules for remote online notarization. And then that will be followed by Bill 378-35 LS, also introduced by Senator Mary Camacho Torres, an act to add a new Section 57108 to Guam to Chapter 57, Title 10, Guam Code annotated, relative to the establishment of a non-expiring Guam identification card for residents aged 65 years or older. I'd like to acknowledge my colleagues that have joining us this morning. We have Senator Mary Torres, she's present. We have the legislative secretary, Senator Amanda Shelton. We have Senator Kelly Mars Taitano, and we have Senator Tello Taidagui. And we also have from the Office of the Attorney General, Stephanie Mendiola. Thank you, Stephanie, for joining us this morning. I'd like to invite Senator Torres to introduce her bill at this time. And please tell us about your bill so we can have an open discussion about this.
Thank you, Mr. Chair. Good morning, everybody, and thank you for joining me at this public hearing. Bill number 369-35 COR is an act to add a new Article 10 to Chapter 33 of Title 5 Guam Code annotated, relative to authorizing the performance of notarial acts by a remote online notary public, and to further add a new Article 11 to Chapter 33 of Title 5 Guam Code annotated, relative to authorizing the recording of an electronic record, and to amend Section 33512 of Chapter 33, Title 5 Guam Code annotated, relative to criminal prosecution of a notary office, and to add a new Chapter 3 to Title 31 Guam Administrative Rules and Regulations, relative to implementing rules for remote online notarization. In short, Bill 369 recognizes the longstanding need to modernize government operations by providing remote online notarization services. There are two distinctions that I want to make first off. One is e-notarization versus remote notarization. At this point, Mr. Chair, it may be helpful to briefly discuss the differences between the two, which ultimately come down to how the documents are notarized and signed. E-notarization uses digital signatures, but must occur in the physical presence of the notary, similar to how one would sign or initial a bank or doctor's office using a stylus and a pad. In remote notarization, the person is not in the physical presence of the notary, but is present through audio and visual equipment, such as a webcam. Electronic signatures are used to complete this process as well. In other words, while Guam Public Law 3315 authorized the use of electronic signatures and records in 2015, present notarizations must still be conducted in the physical presence of a notary public, even if the documents to be notarized are in electronic form. So Bill 369 would update this by permitting an individual to appear before a notary public remotely via two-way audio and visual communication. This would provide individuals a safe and secure alternative to traditional transactions involving a notarial act. To protect against fraud, the bill adopts rules and regulations providing multiple layers of identity verification. And these rules were based off of standards promoted by the Mortgage Bankers Association and the American Land Title Association. As a result, they include a requirement for presentation of a photo ID, credential analysis, identity proofing, and a digital recording of an audio-video communication capturing the notarization of the documents. An online notary public must also require that an individual demonstrate he is neither under duress nor coerced to complete the transaction. The notary is further authorized to refuse to perform a notarial act if there are reasonable grounds to believe that an individual is acting under coercion or undue influence. Should this bill become law, Guam would join a growing list of states with remote notarization services on the books. Currently, 28 states have authorized RON, R-O-N, services, while several more have issued emergency executive orders in response to COVID-19 crisis. For example, about a month after I introduced this measure, Governor Lou Leon Guerrero issued Executive Order 2020-25, which temporarily suspended the physical presence requirement of a notary for the duration of the public health emergency. And despite this temporary authorization, the Lieutenant Governor Joshua F. Tenorio has written to the Speaker of the Guam Legislature, indicating the need to implement remote services on a permanent basis. And so, should the chair permit it, I'd like to read the short correspondence into the record, if you don't mind.
Please continue. Thank you.
So the bill is dated August 3rd, 2020, regarding Bill number 36935. Hoffaday, Madam Speaker. On July 20th, 2020, Governor Lourdes A. Leon Guerrero issued Executive Order 2025, temporarily authorizing remote online notarization services during the COVID-19 public health emergency. The purpose of the executive order was to ensure the availability of critical notarial services in a manner that promotes social distancing and mitigates against the spread of COVID-19. While Executive Order 2025 is intended as a temporary emergency measure, it requires the Office of the Attorney General to develop rules for implementation of standards and requirements for remote notarial acts. The establishment of such rules and the consequent structure for regulation of remote notarial services, even on a temporary basis, affords Y Legislature in Guam the opportunity to explore whether it would be beneficial for Guam to implement more permanent measures to modernize current notarial statutes in 5 GCA Chapter 33 to include such remote services. I'm aware that Senator Mary Camacho Torres recently introduced a bill to this effect, Bill 36935. I believe it would be appropriate and timely for the legislature to determine whether the use of remote notarial services is suitable for Guam on a permanent basis, as many other U.S. jurisdictions have instituted. As we continue to establish systems and generate standards for numerous COVID-19 related services, it is prudent to also study the efficacy of these efforts and to take the opportunity where appropriate to broaden their scope when the public health emergency has passed. I just want to add that while modernizing Guam's Notary Act has always been necessary to keep up with this time, the recent pandemic has brightened the spotlight on the need for remote practices. And this bill would enable parties to conduct important transactions without compromising the integrity of notarial acts or current social distancing requirements. Thank you.
All right, thank you, Senator Torres. We received testimony from specifically the Attorney General's office and the Public Defender Services Corp. And I did see Mr. Jones here earlier. I'd like to also recognize that Senator Teresa Terlay has joined us this morning. Thank you, Senator. Stephanie, would you like to go ahead and give your testimony in reference support? Because I know that all the testimonies, the two testimonies I received are in support of it. So, Ms. Stephanie, please.
Sure, Mr. Chair, thank you, and good morning to members of the committee and other members of this body. We did submit our written testimony this morning, as the chair mentioned, but because it was just submitted, I'll go ahead and read it into the record and then field any questions that you may have. So this is testimony on behalf of the Office of the Attorney General of Guam, dated today, September 29th, 2020. Hafiday Senator San Agustin, thank you for this opportunity to provide testimony on Bill number 36935 COR, which would authorize remote online notarization and adopt rules for the same. Our office stands in support of efforts that move the IT capacity of GovGuam forward, particularly during these uncertain and unusual circumstances we face in the current pandemic. In accordance with Executive Order number 2020-25, effective July 22nd, 2020, which temporarily authorized remote online notarization, RON, we stood up an abbreviated version of the RON program. We've since received 3 applications and approximately 10 to 15 inquiries regarding the program. Given that we have over 500 commissioned notaries public, the demonstrated interest level so far appears low, but we anticipate that the passage of this bill and the establishment of a complete RON program will draw more attention and interest to remote online notarization. We understand this bill was likely modeled after other jurisdictions, but we make the following recommendation to Section 33801I, definitions. This is less of a substantive change than it is an attempt to keep our local statutes Guam-centric. And as a sidebar, because the paragraph is written as a markup, I'll just read it as though the suggested language would be adopted. So open quote, subsection I, open quote, outside the United States, close quote, means outside the geographic boundaries of Guam, a state of the United States, the District of Columbia, and any other territory, commonwealth, or insular possession subject to the jurisdiction of the United States, close quote. We also suggest that the more appropriate placement of the rules for remote online notarization to be incorporated into the GAR would be as Article 3 of Chapter 1, Office of the Attorney General of Title 19 Law, instead of Chapter 3 of Title 31, Trade Practices and Consumer Protection. As a more substantive matter, we ask that Section 3102 of the rules as proposed be amended to maintain consistency with the remainder of the bill by clarifying that only a currently commissioned notary public or a person applying to become a commissioned notary public may apply to become an online notary public. Or in other words, that a person cannot submit a direct application to be commissioned solely as an online notary public. And again, I'll read it. It's a markup paragraph, so I'll read it as though the suggested language would be adopted. Open quote, Section 3102, application for online notary public commission, semicolon renewal. Subsection A person who is or applying to be commissioned as a notary public by the Attorney General of Guam and meets the qualification requirements for commissioning as a notary public, as outlined in Chapter 33 of Title 5, Guam Code Annotated, may submit an application for commissioning as an online notary public by submitting to the Office of the Attorney General of Guam the prescribed application form, including the following information, etc. Close quote. Finally, while we are in support of this measure and we are prepared to establish the remote online notary program, we ask that the effective date be set at 60 days from enactment instead of upon enactment to give our notary program team and our IT team time to address the additional administrative requirements to be put in place by this bill. Thank you again for the opportunity to provide input on this measure. We remain available for any questions the committee may have. Sinceramente, si Stephanie E. Mendiola, General Counsel, Deputy AG, Division of General Counsel.
Thank you, Ms. Mendiola. And we also have Mr. Jones with the Public Defender's Service Corp. Sir, if you like, we did receive your testimony also, so if you would like to read it out loud so everybody will know exactly where you folks stand on it, because I know you're in support so far.
Thank you, Mr. Chair. Would the chair like for me to read it verbatim for the benefit of, I think Senator Teitigui was the only senator I did not email it to yesterday. At the committee's pleasure, would you like me to read it verbatim or just summarize?
If you could, it's less than a page long, and the reason why is because we're going to attach your testimony as, instead of transcribing it verbatim, we're going to go ahead and just attach your testimony. But if you can just read it out loud so the people of Guam can hear exactly your support of the bill.
Sure, it's maybe about 4 pages long, but I'll read the written testimony, Mr. Chair, and then I'll make myself available for any additional comments or questions. But it's addressed to the chair, the committee, and also Senator Torres, the bill's sponsor. The Public Defender Service Corporation was excited to learn that Senator Torres was introducing legislation that aimed at ameliorating some of the challenges our citizens face when attempting to notarize documents. Many Guam residents, including clients of our law firm, have found it difficult to secure notary services before and during our current pandemic situation. As many legal acts require execution before a notary public, our office deemed this an important policy to offer our insight and commentary. And I did outline our policy review team, Director Hattori, myself, and we had the benefit of having 2 legal interns over the summer, a law school intern, Christian Spatansky from UC Davis Law School, who is a graduate of Guam High School, and Caitlin Norton, another Guam product who just graduated from Chaminade. The body of our testimony starts on the 4th page, general commentary to Bill 369-35. Bill 36935 is an extremely comprehensive and complex policy to digest and understand. Fortunately for our office, we had available to us a rising second-year law student from the University of California at Davis. Interning with Public Defender over the summer, Mr. Christian Spatansky was tasked with reviewing the bill and breaking it down linearly as a flow chart. Our goal was to create a visual aid that could be used during a subsequent focus group with our office. That flow chart is not attached to the testimony, but we'll make that available should any of the committee members or senators would like that as a demonstrative. We did conduct an e-notary focus group. Our policy review team, none of us are actual notaries, so we felt important to engage the notaries that we do have within Public Defender Service Corporation, just to offer some insight and perspective prior to submitting this testimony. PDSC has a handful of notaries available at any given time. They are used to execute complaints, petitions, and other important legal documents. Our notaries are primarily investigators and secretaries within our organization. Because none of our primary policy review team members, as I noted, are notaries, we wanted to validate our testimony before this body. We sought to compile a focus group perspective, both of notaries, non-notaries, in reviewing this bill. Several of our notaries were present during the focus group, along with staff members who supervise direct services that require notarial acts. Mr. Spatansky and myself provided a brief overview of the bill and how e-notary services work and how they are structured in other jurisdictions. General commentary was collected. And we outlined in our written testimony just the basics of what we believe is our support for this bill. The first bullet point is e-notary services will be a useful option to have available in many instances. E-notary services is not something new to the United States, as stated by Senator Torres. 28 states have e-notary services in their books. In fact, I believe in our research, some states have been doing this for almost a decade now. It has come around in some jurisdictions, again, for almost 10 years. It is a process that has been structured, implemented, and reviewed in other communities, and the National Notary Association, or the NNA. COVID-19 and the need to socially distance ourselves further highlights the need for an option outside of face-to-face contact. For many, traditional notary services may be preferred, but for others, it may be a welcome option. During the pandemic, it may be the only option. Our second bullet is, although a helpful option to have, Public Defender Service Corporation may not immediately avail itself of e-notary systems. As noted by Ms. Mendiola in her request to extend the prospective enactment of this prospective statute, we too join in the reality that this bill is extremely complex and infrastructures may be necessary in order to proceed. Subsection A of our testimony indicates that, again, in reviewing the e-notary demonstrations from other jurisdictions, our focus group observed the complexity of the process. We are certain that the Office of the Attorney General will have to create and offer a separate comprehensive training and certification procedure for said e-notary certifications. Another barrier that we've identified is the need for special software. The software and equipment necessary to conduct e-notary services will be an additional burden on any individual or entity wishing to provide this service. Without knowing which software would be required by the OAG, one cannot quantify the full cost of engaging in the practice. This is also assuming that an adequate technological infrastructure already exists. Computers, webcams, and fast enough internet access would be needed at the very minimum. The last barrier that we identified, and probably for the most important, is the PDSC clientele are likely not equipped for e-notary. The majority of our clients are indigent. We have known for years that a good percentage of our clients experience difficulty securing their own phone service. The current COVID-19 crisis has highlighted the fact that many of our consumers do not have access to the internet through mobile data plans or home broadband service, nor do they have the devices that would support e-notarial acts. Should e-notary services become available, our law firm would have to brainstorm mechanisms to offer and effectively engage the e-notary services with our clients. And lastly, we wanted to take this opportunity, Mr. Chair, to maybe be opportunistic in a sense. I know that this particular bill aims at adding sections, a very substantial section, to Chapter 33 of Title V. And we wanted to highlight to the legislature the need to address notary services for incarcerated and detained individuals. And I'm going to read off of the written testimony again. During our focus group, a common theme was the difficulty many of our incarcerated clients have with notarizing documents at the Department of Corrections. Many of our detained clients either have no valid identification to begin with, or they don't have access to said means of identification. This causes problems for our clients who wish to execute power of attorneys, guardianships, or other documents necessary for the care of property, the care of loved ones while they are away. For this reason, our office would like to request an addition to Bill 36935. We would advocate for specifically Section 33104, subsection M defines what constitutes quote, satisfactory evidence of identity. It currently lists 1, a passport, 2, an official identification issued by the federal government or state government with the individual's photograph and signature, or 3, personal knowledge of identity. Again, many of our clients do not have valid passports or identification issued by federal or territorial entities. Further, subsection 3 requires the notary to have personal knowledge of identity. Although helpful at times, many clients cannot avail themselves of this option as well. Jurisdictions such as Florida, and we did attach tab 3 to our written testimony, and California, we also attached tab 4 to our testimony, recognize correctional facility identification as sufficient for notarial acts. Our proposed amendment to Bill 369-35 would add subsection 4 to the definition of satisfactory evidence of identity. We would advocate for subsection 4 to read, this is just recommended, should an individual be confined at a detention facility located on Guam, the facility's form of identification and/or demographic information kept in the regular course of business shall be deemed satisfactory evidence of identity. And I won't read off of the voluminous tabs that we attached from Florida and California, but they're very specific as to allowing the satisfaction of identity when the notary is reviewing the documents from a correctional facility located in that particular state. For most detained and incarcerated individuals, there would have been several layers of processes that should have verified their identity. Amongst these contact points are the Guam Police Department bookings, Department of Correction bookings, fingerprint scanning. Examples would be the Automated Fingerprint Database, the Automated Fingerprint Information System, or AFIS, local and federal marshals processing, local and federal probation processing, local parole processing, Superior Court of Guam and district court proceedings, attorney advocacy, immigration and naturalization services, to name a few. Therefore, an individual incarcerated or detained at the Department of Corrections would have encountered many contact points in our criminal justice system that would have confirmed and verified their identity, allowing a notary to utilize the demographic information or other identification documents at the Department of Corrections kept in their regular course of business in order to establish satisfactory evidence of identity would help our clients accomplish many tasks, such as executing power of attorneys, completing guardianship forms so that their children can be cared for, and signing other papers necessary to handle their affairs while detained. In conclusion, the Public Defender Service Corporation supports Bill 36935. It affords an option to execute notarial acts that do not require face-to-face contact. Although helpful to many island residents, public defender clientele may not have the resources currently to avail themselves of e-notary. Nonetheless, this is a worthwhile endeavor that can be launched with private notaries and institutions that have existing resources to offer this particular service. Furthermore, at the most important to our legal constituents, our office would advocate for a slight amendment to Bill 36935. Our proposed amendment would allow notaries public to use correctional facility identification documentation to meet the satisfactory evidence of identity standard of acknowledgement. Thank you, Mr. Chair. That was our written submission to the committee. And as stated, my office definitely supports this bill. We think that it is definitely a process, as we see in our sister jurisdictions, definitely a process that would benefit our community. So I would leave that up to submit that to the committee and welcome any questions or concerns or comments at this time. Thank you.
Thank you, Mr. Jones. Great testimony from both your office and the office of the Attorney General. Senator Torres, do you have any questions on the two attorneys from the two different offices?
I do. Attorney Jones, I just want to thank you and your team for the deep dive into this bill. Your recommendations will certainly be taken into account to solidify the RON bill. And I think we need to be a little clear about e-notarization versus RON. We're really talking about remote online notarization. I just want to ask, though, as a practical question, the ID I can see as a definite problem to getting things notarized for detained clientele. But what currently happens in situations where there isn't sufficient ID and documents need to be notarized? How does your division handle that?
So as a practical matter, maybe I'll give an example without disclosing confidential information. If I have a client who's a mother who is detained at the Department of Corrections and is looking at she has a concurrent federal case and is looking at prospective federal detention for a number of months, maybe even over a year. She does not have any identification, a valid identification to notarize her consent for a guardianship or to even petition for a guardianship. It really puts her children in limbo without notarizing or having her present during the proceedings to place on the record her consent to the guardianship. It really places her children in a situation where if the mother were to be deported or sent off to federal prison or just maybe continued to be detained at the Department of Corrections, her children really have no guardians identified and no one who to really legally take charge of their care and custody. So our clients really face a situation where they're caught between a rock and a hard place, right? They don't have the documents, they can't get the documents because they're detained. And in a lot of situations, it usually goes, in my experience and observation, sometimes we do have CPS cases that give rise because we have children who are identified to have no legal guardians. They can't, the adults caring for them have no legal standing to enroll them in school. And so many times there will be a referral to CPS in order to address the concern. And then before the family court, once those children are before the family court can act. But yeah, Senator Torres, in those situations, it really is, there really are few options available outside of having the parent give consent maybe on the record if they were able to be brought before the Superior Court for guardianship proceedings. But if they are in federal custody, that makes it a bit difficult to procure their presence. And once they're shipped off, either deported if they're before INS or they're sent to federal prison, then they're currently unavailable for even to place their oral consent on the record. So I hope maybe that gives a bit more color to the situation that our clients face.
Yes, but what I was also thinking as you were discussing this is we are also aware from testimony provided by the Judiciary of Guam before the legislature that oftentimes there is also a problem with multiple identifications because people don't, when you don't have a credit history or any key I'm just losing the acronym right now, but generally there are types of questions that are unique to you that are used in security situations that can affirm your identity. But with people who don't have identity, and in the case of the incarcerated people who oftentimes have multiple identities and sometimes multiple social security numbers, I think this issue of identity and what is acceptable, I believe has to, maybe that's a side conversation that we need to have, because I think that the judiciary highlighted how there are issues with even pinpointing precisely who somebody claims they are. And maybe it's slight variations on a name as opposed to a whole different alias. But do you understand where I'm coming from? Or is that even an issue about different identities, or is it just different variations on a name?
Yes, sure. Senator Torres, I do understand. I think definitely in especially with some of our compact impact migrants, they at times will have variations in their names. Maybe their birth certificate might have a different spelling, or maybe a completely different name altogether. I think if this was a commentary by the judiciary, I think definitely, in some instances, there are aliases that are compiled. And that's why in our written testimony, I listed all of the potential contact points, and definitely with all those contact points, you do have a compilation of identities for this particular person, right? We can verify that this is, Will Jones or William Jones. This is William B. Jones, also known as Will Jones, also known as William Jones, also known as Attorney Jones. And the criminal justice system, our partners definitely share that information. So if you were to see William Jones charged in the Superior Court of Guam, you'll likely see all of my aliases to ensure that I'm being properly identified. And so I can understand your concerns maybe that pinpointing which particular name we are notarizing might be an issue, and maybe this might be an opportunity for further discussion. But yes, I definitely agree that that there are persons who engage our system that go by various names. But I also would like to point out that our system has been improving and compiling all of the aliases and AKAs for the people who come before the criminal justice system.
So I definitely would like to, I think your recommendations are very good, and I think they're relevant to the situations on Guam. And we would want any legislation to have broad effect and advantage. So we will definitely take your things into consideration, and I'll be reaching out to your office as well to have side discussions so that we can fully vet, and I can be sure that I'm on the same page with your intentions as well. But thank you very much. All good, and I'm very grateful for the effort that you put in to this.
If I may, Mr. Chair, just briefly.
Yes, please.
Thank you, Senator Torres, and I hope that when we suggest this amendment, we would definitely we wanted to just bring the attention to this issue to the body. Definitely, if the committee deems it inappropriate to include this amendment in Bill 369-35, we would understand. But I think I'm getting assurances from the senators present that you hear us clearly, and we would definitely love to engage in conversation to maybe, at the very least, include this in a separate bill. And really address the lack of ID issue for our clients, but the lack of ID as it relates to notarizing documents so that their affairs can be taken care of while they're detained or incarcerated. So thank you for the opportunity again, Mr. Chair.
All right, thank you. Senator, do you have any other questions? If not, I'll go ahead and ask the other colleagues to join.
Just briefly to Attorney Mendiola, you've had to step up an interim program based on the Executive Order 2020-25. And with the rules being put into the bill now so that it jumpstarts you, right? You don't have to promulgate rules separately.
Yes,
I thought it was a good. Would 60 days really be the amount of time that you would need, or being that you've had a go at it, so to speak, with the interim executive order and with the rules being in place, could that 60-day implementation be shortened somehow?
It certainly could, and we will do whatever we need to try to work within what the legislature decides. Relative to the program that the temporary program under the EO, it is far more abbreviated in that we have not set up internally a full SOP for what would be required of both our notary program and our IT review, the way that it's set up under the proposed rules in the bill. So the 60 days would allow us to set up those internal SOPs and then also familiarize our notary program with the requirements part, and then our notary team, and then familiarize on our IT side the different third-party options and the technology that we need to look out for. That extensive review is not currently in place. We tried our best to set up something under the EO that would allow us to move forward. And so it really is limited to a notary providing us the most basic information and identifying what software they would use. And then we're mostly just reviewing it for legitimacy purposes. It is definitely not as extensive as what the rules would allow. So that was our proposed suggestion, but if you decide to shorten it, we will do our best to work around it. I think the issue with just upon enactment, that's more problematic because if it gets passed within the next couple of weeks, signed into law within 10 days, then we don't yet have that set up. So we wouldn't necessarily have step one is the form available, for example. We wouldn't have the chits available to pay at Treasure of Guam. So things like that we would just have to adjust internally. So if not 60, then at least some time beyond upon enactment.
Thank you.
Thank you.
All right, so that sounds more like between 30 to 45 days then. Okay, we're leaning on that. All right, so I'm Madam Senator Amanda Shelton, my vice. Ma'am, do you have any questions, ma'am?
Thank you very much, Mr. Chair, and thank you to the author of this bill and to everyone here to testify today. I'm of course very supportive of this legislation and see how this bill will benefit our public, benefit our notaries as well as our general public. After over the course of the pandemic, we received several phone calls from our Manamku, many of our WAR claim applicants who are seeking assistance to have their documents notarized again to update their applications at the request of the Foreign Claims Settlement Commission, and trying to connect them to a notary during the time of PCOR 1 was very difficult and of course frustrating for them and their families. And so this type of program allowing for the remote online notarization could be very beneficial. And so I know it was difficult to assist them, so I appreciate this. And it is sounds like a complex program. And you mentioned Attorney Mendiola that you'd like the 60 days or whatever additional time that we'd give you. I'm also wondering if the Office of the Attorney General, with this additional responsibility, has the resources, the human resources, and the resources, technology resources to carry this out and to give the authority to these notaries public.
Sure, thank you for the question. Human resources is always a tricky issue. Again, I think especially coming out of budget session, we are all working within our means. We do have staff. We do not have staff that are specifically dedicated to the notary program, but we have staff in our administration division who cover both their administration division duties and then notary program duties. For the tech side, thankfully, the rules that are proposed to be adopted through this bill, they actually just address what the standards of the technology need to be. And the onus is actually on the applicants to identify what software they would use. So that is a tremendous help to our office because we only have to focus on review of the software identified by applicants, or whether it's online software, what have you, the third-party provider. So that's a definite help. On our end, we have the resources we need so far that we're aware of in terms of reviewing electronic records and maintaining a repository of records. Our office has recently transitioned to G Suites, which offers us the use of Google Drive, and we have unlimited storage and we have file sharing capabilities. And so the ability for us to retain records shouldn't be an issue. But again, going back to my earlier mention of familiarizing ourselves internally with different third-party programs or third-party software for remote online notarization, we would have to look out for what types of document files or record files the notaries would submit. But the short version is yes, we're prepared to stand it up within the resources we have now, and the emphasis would be, the onus would be on the applicants to identify what software they would use. So to the extent that I think it was Attorney Jones who mentioned the expense of using systems, that would really fall on the notary applicant, of course, and then could be absorbed through their fees.
Okay, thank you very much. Glad to hear that. Thank you. Thank you very much, Mr. Chair.
Thank you, Senator Amanda. Senator Kelly, do you have any questions, ma'am, you'd like to pose to the two attorneys here from the two respectable offices?
Yes, I too am was pleased to read through this bill, and as was noted, it's very comprehensive, and there's quite a lot of complex detail to it. And it was very good to hear the support testimony that we did this morning. That means a lot. They have the background and the ability to do, as the author was saying, that deep dive. And so that feedback is incredibly important. I would like to understand a bit further. There's a section there about identity proofing and credential analysis. So I was hoping that maybe Attorney Jones or somebody could detail that a bit using that third party. I'm just trying to sit in my own mind whether there's a cost involved. It's set up in 28 states, so that gives us a lot of assurance that this has become very standardized. But if there's somebody who could outline that process a bit so we could understand it just a bit further.
All right, Attorney Jones or Ms. Mendiola, would you, either one of you, like to speak on that part?
I can take an initial stab at it. First, yes, the fact that it's adopted in 28 other jurisdictions also gives our office as the administering agency some assurance that the third-party services that will be submitted to us have already been around for some time in their standardized processes. That the portion of the process that relates to identity proofing, to get to your question, would be something that we would review to ensure that that third-party provider offers. And what we would do on the IT side is just do a deep dive into their security certificates and basically just take everything that the rules requires for security standards and make sure that that third-party service provider offers that same level of security. I can't necessarily explain the IT behind the identity proofing, but certain types that are more familiar that many of us might have seen in online operations is, for example, if you're trying to sign into your bank account, or you're trying to sign into PayPal and you sign in from a new computer and you have to go through an extra step to verify your identity. Those are the types of steps that the third-party service provider would need to have in place. More in depth is if you're, for example, applying for a loan or requesting for a copy of your credit history, you may, credit report, you may run into the company, their online website. They would require you to answer questions before you can even get into your account. And then that's where we wonder, are we being spied on, or how much are we really being observed? Because some of the questions will tell you what your address has been for the last 20 years. It'll give you like 6 options, or it'll ask what your last 4 digits of your phone number is, and it'll give you 5 options. And you have to identify yourself through the information that the company is providing. And they're using different databases that they have access to for personally identifying information. So that's what gets to the knowledge-based authentication and identity proofing. And then credential analysis, of course, is just through verifying the government issued ID, etc. The way the tech works behind it, I can't say, but those are the features that we would verify on the AG's office side that the third-party service provider that's identified also offers.
Okay,
All right, thank you. And
that
Attorney
really
Jones?
helps.
Senator
Oh,
Kelly will
yes.
have Attorney Jones be able to comment
Did
because
Attorney
he's
Jones
gonna be able to
have
second this.
additional?
Oh, I would have deferred to Ms. Mendiola. She's definitely expressed and stated it well. I too do not have any knowledge as to the particular technical aspects of how these softwares or these third-party entities work out how they verify their data. But in our research, our basic research and observing some of these demonstrations, specifically, I think we saw a video demonstration out of Pennsylvania, wherein identity is verified by your credentials, identity is verified by answering a bunch of questions. How those questions are created through algorithms or whatnot is well beyond me. But it seems very complex in terms of which, and very specific to which third-party software you decide to employ. Thank you.
So just Masi for both of those responses, and it again helps give me additional assurance to know that there are ways that the AG's office can validate and verify these companies. I do think with our geography and maybe a significant portion of our population coming from islands elsewhere, they may have less of an electronic or digital identity. I don't know, but that helps me, like I said, be assured that the Attorney General's office has a way of validating that these companies are doing their work. And the other question that I had was, and it's probably because I don't know enough about it. I just wondered if there were any concerns with working outside of the US. So it's good that there's that tie into the US. So it doesn't necessarily open the door for everything. It still is tied into the US. But are there any concerns in the research that you've done that need to be taken into account if we're notarizing individuals outside the US?
So I can't say extensively what the legal concerns might be, but as a preliminary matter, one concern might be that a notary, of course, becomes a potential witness because of the taking of executing the notarial act in the context of a legal transaction, right? So there is always a potential for a notary to be called as a witness in the event that certain transactions become subject to lawsuits. And what we will do on our end is to prepare our notaries should this be adopted. And of course, it's a policy question that's left to this body. We'll be sure to remind our notaries of that because that will be a change in the law. In our abbreviated program that we stood up under the EO, we did not allow for the principal, who's the signing party, to be outside of Guam. We required both the notary, of course, and then the principal to be physically located in Guam. I don't know myself the legal history of the connection between the legal issues that might be raised with the notary having some connection to The notary executing an act that has some connection to somebody who does not have a connection in Guam, but it's something that we can look into and come back if there are any significant legal issues. I know that relatedly, there was a situation with our divorce laws that addressed the 7-day divorces that touched on the issue of the connection between the parties and being physically located in Guam. I'm not personally familiar with the history of the legal issues, but we can look into that. But otherwise, it is something that I believe is done. It's done in multiple jurisdictions. I think the longest one might be Virginia, who allows outside of the US notarizations. So again, thankfully, we wouldn't be reinventing the wheel in that sense. But that's pretty much it so far, is just the risk that, I mean, it's the same risk that every notary faces, whether the principal is required to be in Guam or not, but it's just, of course, additional risk if you widen the pool for geographic locations. And that's it for us for now. I'm not sure if Attorney Jones has anything regarding that.
Yeah, no, there's always that risk, right? And that was one of the things, just quickly, that was brought up during our focus group. As the body's well aware, public defenders looking at launching an elder law center with a partnership with Guam Legal Services and Public Health. And the attorney who's spearheading that effort currently did bring up in reviewing this bill, just the natural issues of fraud that exist in executing legal documents generally, and the fact that he would have to look at whether or not our new law center would avail itself of the services off the bat. Maybe certain internal policies within our organization would have to be put into place in order to use an e-notary or a distance notary. But that was, it is always a reality, and it was something that was brought up during our focus group.
And I mean, the notary would have control. They don't have to, I imagine, they don't have to offer those services. They could limit them for themselves. And it's important to know that the AG's office at least will continue to look at this and provide feedback to the author, who I know will be very conscientious about continuing to work with these offices. Sejuis Masi, Mr. Chair, for letting me ask those two questions.
Thank you, Senator Kelly. Senator Therese Terlai, do you have any questions, ma'am?
Yes, Mr. Chair, thank you. I want to thank the Office of the Attorney General and the Public Defender who've testified on this bill. And I support the idea of the bill that we are going to allow notaries to perform, especially during this pandemic. Made it very obvious that we need this to be able to be done for transactions to occur while we're trying to social distance from each other. But like the previous Senator, this is a huge expansion of policy that allows notaries on Guam now to notarize off-island signatures, and and that's a big shift. And I wanted to ask, but I think it was clarified that the Attorney General's representative here today said that in their temporary policy, of course, they have not done that because that's not allowed right now by law. With that and the increased risk that was testified, right now the Attorney General's office is squarely in charge of all notaries on Guam. They're supposed to train them, they're supposed to oversee them, regulate them, take away their commission if they find they're not able to perform correctly or in accordance with the guidelines. And I want to ask, yes, if your office, this is a kind of a repeat again from Senator Taitito's question, that is your office able to do this on this type of basis? And does it mandate the use of a third-party software? right now you're saying notaries during this pandemic are allowed by executive order to notarize, but not necessarily with the use of a third-party software. And is that correct? On a case-by-case basis?
I'm sorry for any confusion. No, under the abbreviated program we stood up under the EO, the notaries are still required to use a third-party software. They're just required to identify to us in their application which software they intend to use. So it is still required, yes.
Oh, okay, then could you tell us about the ones who have signed up for this? How many are there, and what type of software do they use?
So there are actually only 3. They are all from the same title company, and so the software they've identified they have all identified 2 software. One is notarycam.com, which is actually the first software, third-party software in the US that allowed for remote notary, and that is open to anybody who is commissioned as a notary to use. The second one, I am trying to pull up the name, but it's actually not a standalone notary software. I believe it's called Pavaso, P-A-V-A-S-O. It is a software that's designed for a title company, but because staff of the title company have to notarize, there is a notary function within that software, but you can't access it unless you are associated with the title company, which the 3 applicants are. We have not yet finalized any applications or commissions any online notaries yet. I believe the final step, if I'm not mistaken, is that we're waiting on them to provide their insurance bond. So the local insurance companies are now aware of this because of the EO and the program that we stood up through the EO. So they're working on offering this, which is also something new to the insurance industry in Guam.
So for, let's say, so right now, a person, for example, who wants to sign a document, an application or something that has to be notarized, is not able to avail of this temporary executive order unless they go through a title company at this point. For example,
no, it was just an example. So notarycam.com, any commissioned notary can sign up through that company. But I was just, relative to your earlier question about the ones that have applied so far, it just so happens that all 3 of them are from a title company. And so the software that they've identified is the general notary software, and then the title company specific, which offers a notary option. Yes.
Okay, that's great. Okay. And then, so the AG, according to the fiscal note says they were BBMR was unable to determine the fiscal impact, because they are awaiting response from the Attorney General's office as to impacts on additional training that will be required, additional personnel, education, administration, and equipment costs. And that was done though in July 29. And I guess I would ask you, Mr. Chair, if there's an update on that fiscal note, or if we could get one on.
Yeah, I would of course defer to the chair if OFB has received an updated fiscal note, but as far as our office's response is concerned, I will say that yes, at the time that BBMR requested our input, we had not yet been able to complete thorough review of the bill. And so our update, as we addressed today, the portion of the bill that requires us to adopt standards and to implement, all of these different things. I was laughing, but I was also serious that it's something very beneficial to us that the bill also included the initial proposed rules, because that's what's going to help us to be able to move forward the quickest. So in terms of what was addressed in the comments of the initial fiscal note, we have since resolved that by identifying through the rules that what the rules identifies, it basically already puts in place what we would have needed to do, if that's the short answer for our office update. Now, I will say that what I mentioned earlier about our office trying to familiarize ourselves with these programs, we don't have that yet. The abbreviated program we stood up under the EO is going to be our baseline if we can get this group of applicants commissioned, and that'll get us started with familiarizing ourselves with what the programs are, what the type of notary records are, how the notaries would provide them to our office, and then how we would retain them. So, you know, this could very well be a work in progress, but the fact that the rules are included is a huge first step.
All right, and then there was a mention of a commentary by the Judiciary, but I don't see that in our packet. If that's available, if that could be, if you could provide that to us, Mr. Chair. And then finally, for the AG's office, so if the AG, when they oversee, well, they've commissioned Government of Guam notaries as well, and so this would also allow them to do that, Government of Guam notaries. And yes. Then the notaries would have to apply separately for that, and they would have to be, according to these rules, they would have to avail themselves of some type of third-party software, I guess, to be able to confirm the identity. Is the AG going to be able to, how would you, I guess, oversee that? Or how would you be able to, if there's a suspicion of fraud, how would you be able to view that? Or is the AG, Attorney General of Guam, able to avail themselves of the, of the record of these transactions? I know the notaries are supposed to keep them, and it's between them and the software company, but what about the Attorney General's office?
So that's what we would look at in terms of the records that the notaries would produce. So we would first do a review of the third party that the applicant provides, that the applicant identifies. And then we would look at the level of security they provide, what type of records we can expect. The rules go, in terms of fraud, that's very general, but I'm going to assume, for example, what the rules address is changes to documents, that being able to detect changes to documents after an initial notary action is taken or something like that. So we would essentially just try to figure out from the third-party provider that's identified what our office could expect from record keeping from that provider. And so that we would have on our records an electronic version of a seal, a journal, etc., the details that we would review in a traditional notary setting, in formats that we're able to actually review and retain. And then if for whatever reason we can't confirm that the third-party service provider will provide those type of records, if there are, everything is generally cloud-based or internet-based, right? But if for some reason there are issues with compatibility or what have you, I can't think of other examples right now, but we're not required to accept the third-party provider that's identified by the applicant. We're basically going to approach it as you identify the provider and we will vet that provider. And as long as we can work with that provider to figure out how the records that will be submitted we are able to review it and meet all the requirements that that are put in place for us to maintain, then we will approve it. But if not, then we won't. If that makes sense. Does that answer your question?
Sure. So is there a difference in allowing them to notarize can't remember the term that it used, but the bill uses, well, in any jurisdiction, I think. So is there any difference for our notaries on Guam notarizing documents where the person is residing in who's signing, whose signature is being notarized, is residing in the United States or residing in a foreign country? I know every country and every jurisdiction has their own laws on how their notaries will perform. So does that affect us? Can we pass a law that allows notarization of a signature in the Philippines, for example?
So if I remember correctly, the rules actually address the outside of the US, either the statutory section or the rules. In terms of the notary's responsibility, the notary just has to not be aware, so kind of the inverse, that there's anything wrong with or illegal about the document that they're notarizing for the person. But again, even if the person is outside the US, the document that's being notarized has to be tied to a transaction that is also tied to the US. So the notary still has to make sure that in review of the document, okay, this transaction has something to do with a transaction within the US, and I as a notary do not acknowledge that having this person execute this document is against the laws of the Philippines, for example, in your example. I don't know if your question is more for our office reviewing that. I don't know what the specific question is, but I don't imagine that we would look at outside of the US transactions and then conduct a legal analysis for that transaction with that notary, that principal, and the particular document. But like we've done in the past, we cooperate if there are any legal inquiries into a past transaction.
Well, my question is, of course, because when we're in court, I mean, the notary becomes the central focus of the case. For example, if a document's notarized and they question whether, something is off, and so, notaries, they have a lot of pressure on them to really identify these people, and they're able right now to hold documents in their hands, for example, passports, IDs, confirm identities. They do this themselves. And I just wonder when they are being tasked to do this through a Zoom meeting, for example, like this with a person, and to confirm that identification is even valid, I think is I don't know, it might be challenging. And that's why I'm wondering if the Attorney General's office is going to, play a role in that, because obviously you're going to have to train them how to do this. And I just curious if you've gone as far as looking at how to train for, authenticity of those types of things, especially in other places.
Sure. So to clarify, we actually are not statutory obligates. The statute doesn't require our office to provide the training. We approve the training. So for example, we use I forget the name, but like the course that we have for traditional notary, we don't actually offer or host the course. We approve the course that applicants can take, which is it's out of the National Notary Association. But
test.
Anyhow, so that's
you give the test, and you give you test them.
Yes, so that's what I was going to get at. So the course and the training we don't provide. We do administer the exam. For the courses or training, we review and approve them, and then for the exam, we host it ourselves. So just a bit of a distinction, because it had come up in earlier conversation. To get to your point of whether or not we're going to be able to train remote notaries or online notaries about how to do this, if that becomes the obligation of our office, which it currently is not the way the statute is written, then we would have other issues. But because the current proposal is to require us to review what the proposed rules are and confirm that the programs the notaries are using meet those specific standards, that's what is doable for us. So when you're touching on what the notary is required to do, if they later become called into court to ask about their actions, there's a baseline, and it's really a reasonableness standard, right? To add a little legalese, for the notary to, first of all, have very good record keeping skills, which is going to be the biggest thing. And then to be mindful of what their responsibilities are, and then to always exercise due diligence in executing those responsibilities. So in the case of a court hearing, if the notary can provide, so, I mean, sometimes the notaries don't even get called because all of the documents get provided. But if the notary gets called, as long as they can verify that they did all of the things that was required of them and didn't do things that were prohibited, then that's the baseline. And for our office, what we do is we have gone back to pull records of prior notary journals, of commission certificates for notaries at certain times. We have assisted, if the notary can't be found, we've assisted to look for particular transactions in journals, etc. But
All right. Yeah,
yeah,
maybe can I just
would
rephrase?
on it.
Yeah, the question is just simple. When it's the Attorney General's office that's commissioning the notaries that we are relying on for, like, the standards, right, to be enforced, to be uniform. And of course, we want to rely on our notary acts, so that our transactions are valid and we can withstand challenge. But so the only way you can do that when you're commissioning them is through the testing of them, right? And now that there's a third-party software involved, I'm not sure, how far you're going to go into seeing, what their interaction is with this software. But the notary still has to to visually compare the following for consistency: the information and photo presented on the credential itself, and the principal as viewed by the online notary public in real time through audio-visual transmission. And that's all I'm asking, is when they're supposed to look at that credential itself remotely versus, personally, that are you able, I don't know, I just wanted to know if the Attorney General has thought about that and how they are able to assist them in that regard, to, especially if we're going to notarize on Guam, I think, that's easy. But to do, everywhere else, I just want the Attorney General to be on top of that and to make sure that we are accurately, the notaries are, even up to date with just the credentialing, I guess, in other places, and whether those can be obtained, easily through fraud or not. I'm not sure. I don't know what the issues are with this. Have you researched that? Are there, issues like that elsewhere?
We have not researched what the legal issues are with that have come up over the past years with other jurisdictions that have this as it relates to fraud. What I will say is this, maybe this answers your question. So if we're not setting up a training or setting up a course that we would then offer, we would approve the ones that are available, and then we would administer the exam. So to answer your question, the portions that would be required of the remote online notary, if that is what would be covered in the exam, we would do it from a knowledge-based level, right? So they would have to demonstrate that somehow during the exam. So that goes back to what I was asking earlier, is even if you don't allow us 60 days to put this in place, something beyond upon enactment, because this is the time that we're using to familiarize ourselves with the different third-party software, with the process that the applicants are going to have to go through, with the type of records we can expect from applicants for online notary, and then allow us to figure out how to measure it, how to review it, how to, to carry out our end of the program. So
It-
for the
okay,
exam part, that would be the demonstration of their knowledge, if that answers your question.
well, that's what I'm hoping you're going to cover. Just my last question, Mr. Chair, is just in your temporary program that you set up, does it require that a physical interaction occur after the e-transaction or not?
No.
Okay. All right. Thank you, Mr. Chair.
All right, thank you very much, Senator Therese. Senator Teller, do you have any questions, ma'am, you'd like to pose to any of the attorneys that are present from the Public Defender and the Attorney General's office?
Yes, I do. Thank you, Mr. Chair. But many of the questions I had have already been asked and answered. But I just want to do, I truly believe this bill, it's a great service to our community, considering the situation we are in. I think we're learning from COVID certain things that we can do, that makes it more convenient, allows a less, manpower. But definitely accountability is important. And I'm glad to see, Stephanie, the work you did regarding this legislation, and Attorney Jones, and I should say Attorney Mendiola, I got to get used to that, but Attorney Jones, to have that kind of assistance and help to go to research this. I have a copy of it. I was able to get it on the chat. I will definitely read through your testimony. Has a wealth of knowledge and knowledge, as well as circumstances that we can look into with regards to how this can really work. When I read this legislation, the first person I went after were certain people at title companies. And I actually I forwarded this legislation to them to have them look at it. And one of the things, Attorney Mendiola, that was brought to my attention was something that you mentioned earlier with bonding. That some of them are having a difficult time with bonding, and to allow this kind of insurance. Do you hear that more often now? And do you think there's going to be an issue with insurance companies to allow bonding, especially when it's outside of Guam?
I definitely can't speak to whether there are issues for outside of Guam. There isn't anything in particular that I've been aware of. It was more of just a general matter that the insurance companies, this was new, and the insurance companies weren't yet aware that this might come to pass. Since our standing up of the EO, there are at least 2 insurance companies that offer the insurance for remote notary. And as I mentioned earlier, that's the last step for our current applicants that we're waiting on in order to finalize their certificates. So hopefully there aren't any issues, and it's just a matter of adjusting to offering a new coverage type for Guam. But otherwise, that's something that we could keep the legislature posted on as well. If we detect that there's an operational issue, then yes.
Right, because a lot of it has to do with getting their bonding in order for them to first qualify. And I think as an insurance company, I think they're going to need to see some mechanisms that are in place to ensure less fraud, or the possibility of fraud to happen, and they're going to base it on that. And I think by staying close with these insurance companies to keep them abreast. And it was kind of funny that you brought up, speaking of, you kind of laughed by the fact that the rules and regs are already included. It's definitely trying to move this legislation through, which is very important, I think. There's a lot of people, Manamkus, as mentioned earlier, but mostly these title companies. And having the rules and regs is usually, traditionally, it's done with a AAA process and go through it. But I know that Attorney Jones, as well as yourself, looked at this thoroughly, and I was hoping that we would have other industries that utilize notary to make comments on this as well. And that's why I sent it to this one title company, if they can provide some feedback. And they're very supportive of this measure. It's very helpful. And I know that the former, Senator Trelahi mentioned something about off-island. And a lot of these title companies have individuals who live in the Philippines, but they have property here, and they want to sell it, and they need to get the their notary. And in the past, they've actually had flown from Guam to the Philippines just to get a signature, in one day and then fly back, which is very costly, for both sides, both parties. So in this legislation, I know in your section where you made an amendment to section 33801, you crossed out some certain areas and just put other territories, Commonwealth, insular possession subject to jurisdiction. That you're talking about outside of the United States. So it was brought about the Philippines. In the event this individual is a US citizen and is off island for, let's say, medical, which unfortunately a lot of our Manamco or people who have illnesses have to go to the Philippines and they need a notary. Is there anything in here, as long as they are US citizen and utilize a notary, a certified, how do you call them, notification or notary, certified notary person in the Philippines, that this would work versus someone who's not a US citizen in the Philippines and go through a notary? I mean, it's kind of confusing, and that was the question that she wanted me to ask you. In the event a title company needs a signature from someone who lives in the Philippines, who is a US citizen, or a non-US citizen, would it make a difference to go through this process of RON? How would it work?
So my recollection is it's not citizenship based. I'll defer to Attorney Jones if he recalls reading different, or of course to Senator Torres. The nexus between the notary, so the notary has to be in Guam, and then the principal, who's the person signing under the proposed bill, could be outside of the United States. And so that would be the Philippines. I don't believe that there's a citizenship requirement. The requirement would be that the transaction, so the document that the notary is notarizing, would have to be tied to a United States transaction. So if it's if someone in the Philippines is trying to sell land in Guam, that's your nexus. The land is physically situated in Guam. Their citizenship status, if I recall, won't affect the transaction.
Okay, yeah, that's what you mentioned earlier. I wrote it down that it has to be US, regarding something in the US with regards to the notary. Yeah, that's put there. Singapore, US, yeah, the title companies, rules and regs. Yeah, everything else was answered. Greatly appreciate all the hard work you put into this, and taking your consideration of all your requested amendments to be made. But look forward to this. And I think that the timeline, Attorney Mendiola, the 60 days, before this bill gets on the floor, if you see that it may take a little bit longer because of the insurance bonding or the issue with that, or trying to get more input for the rules and regs, just so that it's clean. Because the last thing we need to do is taking a notary and having it being litigated because they believe it's fraud or nothing was followed correctly, so I appreciate you staying on top of that. Thank you, Mr. Chair, for the opportunity. Oh, and before I go, I just wanted to do a shout out. It's my dad's birthday today, and wanted to wish my dad a happy birthday. Okay, thank you.
Great, all right. Thank you, Senator Tello. Senator Torres, my only comment to your bill is I'm in support of the bill. I like the comments made by both the two attorneys from the Attorney General's office and the public defender. And I know I'll be getting with you, Senator Torres, and we're going to tweak the bill and we'll make it work so we can get it out and let's start helping the people that are in need of this help. Senator Torres, do you have any closing statements at this point?
Yes, I'd just like to thank everyone for your review of the bill and for your very good and substantive questions and comments. What we have to acknowledge is right now we are in a global type of situation where a lot of our transactions are done online. And while there is some speculation about, this idea of doing things virtually, The beauty with the RON bill is that it requires you to go through a third-party custodian, a platform where knowledge-based authentication occurs, identity proofing occurs. I mean, if anybody is involved in online banking or credit card transactions, or even making any application online, those types of security precautions we know are quite arduous. And sometimes one little mix-up or mistake will cause you to not go through. So that's the way that this RON program is being stood up. But I think what was pointed out too is the lack of physical contact with the notary has been a great deterrent to getting a lot of transactions through. This bill was actually modeled after the Mortgage Bankers Association, American Land Title Association model legislation. So it has, and as many of you are aware, a lot of the transactions in real estate are occurring remotely right now. But in terms of fear of fraud and identity, I think that a lot of the verifications and authentications are in place with this RON program. The record keeping is, I think, unlike anything that we currently have with notary services. Under this RON program, you will have a video recording of the entire transaction, which will then be stored in the records for up to 10 years. So any challenge or any test, imagine that you can rely on something written, but to have an actual recording, I think, is beyond what many of us are accustomed to in terms of proof of authenticity of a transaction. But I clearly will work with the Attorney General's office to have further discussion with the Office of the Public Defender Service Corporation to address some of your concerns with indigent clients. Maybe it is for another bill. Maybe they won't pass the knowledge-based authentication if they don't have ID now. So those are some of the practicalities that we have to talk about, and maybe there is a subset of this bill that we can do to address your specific concerns. But Mr. Chair, thank you very much for conducting this public hearing today, and especially to the Office of the Attorney General and Public Defender Service Corporation. I truly appreciate all the effort you've put into this as well. Sidos Maasi.
Thank you, Senator Torres. That being stated, the committee will continue to receive testimony on this bill 369-35 COR. Please submit your testimony to the mail room of the Guam Legislature in the Guam Congress building, or through my email at senatorjoesaugustine@gmail.com. It is now 10:35, and that will conclude the discussion on public hearing on Bill 369-35. We'll now proceed on to Bill 378-35 LS, also introduced by Senator Mary Camacho Torres, an act to add new section 57108 to Chapter 57, Title 10, Guam Code Annotated, relative to establishing of a non-expiring Guam identification card for residents aged 65 years or older. And I'll be close to that, and I'll be looking forward to that one. For the rest of you, I'll see you when you get there. Senator Torres, if you can please go ahead and introduce your bill, ma'am.
Thank you, Mr. Chair. Bill number 378-35 LS is an act to add a new section 57108 to Chapter 57, Title 10, Guam Code Annotated, relative to establishing a non-expiring Guam identification card for residents aged 65 years or older. It's a very straightforward measure, Mr. Chair. In fact, I think it is so welcomed by the public that I've had many phone calls asking me what the public law number was for this bill. So I'm glad that you rushed it to the public hearing process, because I know many Manamco are looking forward to this benefit for them. Right now, with the Department of Revenue and Taxation, ID cards must be renewed every 8 years. And while we recognize that valid ID is necessary to access basic services and benefits, the renewal process may be burdensome for older residents due to health issues or lack of mobility or transportation, and most especially difficulty locating their primary documents. In response to these challenges, several jurisdictions in the US currently provide a lifetime card for their senior citizens, allowing them to maintain official government-issued ID without worrying. Of those states that provide services, the average age for permitting a non-expiring cards is about 65 years. So this bill provides a lifetime card that is not a real ID compliant card. And the reason for this is that it is based on federal requirements with the real ID. Under the Department of Homeland Security, states must recertify their compliance with the Real ID Act every 3 years on a rolling basis, as determined by Department of Homeland Security. So as a result of this requirement, there's no state that provides a Real ID lifetime card because it would be in contradiction with the federal regulations. And I'll just end with that. I think that, you know, many of us, Senator Teitig, it's just expressed her father's birthday today. And one of it was very frustrating when my mother realized that her driver's license was expired and tried to get a Guam ID. She no longer drives at age 92, but she had to get original documents of her marriage certificate from 60 years ago, of her birth certificate. You know, it's just, and it was insane what it took to get that for a Manamco, only because she wanted to withdraw money from her savings account and she couldn't even do that without an ID. So I know that a lot of people just need these, you know, as they get older, as they progress, it becomes more burdensome for them to get around. So, you know, let's not put one more burden on our Manamco. And like I said, most people are asking what's the public loss number for this. So I think, Mr. Chairman, we owe them this before, clearly before Thanksgiving. Thank you.
Yes. All right. And you know, and I echo also the same statement you made with your mom. I had to take my mother to revenue and tax, and it was ridiculous. She had the old Guam ID card that said it doesn't expire, and then it did expire. And I agree with you, but I'm almost sure that the Department of Revenue and Taxation can give out the ID card as if it looked like a real ID, in compliance with the real ID, but not something that they were required to renew every 5 years. It'll just become permanent on the bottom. That should be an easy one. And you're right. And many of the Manamkus have been questioning, what is this? I'm the same person. I've had this for 50 years, and then I need to renew it. And I agree with you, and I'm in full support of this bill. Does anyone would like to speak? Senator Amanda Sheldon would like to speak on this bill, ma'am.
Thank you very much, Mr. Chair. And again, I'd like to thank the author of the bill for this. And I agree with her. We should give our Manamku an early Christmas present and pass this as quickly as we can. I have to tell you, we've also had the calls in our office, Senator Mary asking, what is the public law about the ID for your bill? And I had to tell them, not yet, wait a little bit. And I'm sure we'll get to it very soon. And we've heard very unfortunate stories in our office as well of Manamku going to the bank and being turned away because their ID is so old that they don't look like themselves in a Guam ID from 20 or 30 years ago. And that's all that they have. And, you know, they're not going to go line up at DRT to get a driver's license because they haven't driven in just as long. And so this to make life a little bit easier, to give them that comfort, our Manamku, I'm very much in support of this bill, and I thank you, Mr. Chair.
Thank you, Senator Amanda. Senator Kelly, do you have any questions you would like to pose to or make any statement in reference to this bill, please?
Mr. Chair. Yes, you know, I also support the concept of making it as easy. When we get older, I too assist my mother. The paperwork that's involved with just staying healthy and going to your medical visits and other things, there's just an enormous amount of paperwork in the United States in living your daily life as a Manamku. And so I do agree that the more that we can simplify this and streamline it, especially if there aren't the issues related to, let's say, a driver's license. For a driver's license, you still have to prove that you're legally, you legally can see, and things like that. But with just a simple Guam ID, that has lesser requirements. So I was trying to think of the reasons why we might be requiring people to update their ID cards. And some of it was mentioned a little bit earlier by a previous speaker, because the one I remember hearing about why that there's a different time requirement for children versus adults and so forth is just the change of appearance over time. I imagine at 65, you're pretty well set, but it doesn't mean, I suppose, that they couldn't go in to update their card if they chose to. I guess, yeah, in just thinking that might be one small point to consider. Somebody at the age of 65, if they live to 85 or 95, there might be enough of a change of appearance, maybe not drastic. You could still see them in there, but that was the one point that I came across. If I could ask the author in her research, is there any other point that came up that is the reason that we require people to go in every 8 years or so for an ID update? Other than that.
That could very well be it. But the interesting thing about the states that have non-expiring IDs is it goes as low as 60. It's anywhere from 60 to 75, I think, or 60 to 70 is the range. So I think what we also have to consider is life expectancy. If you expect that people are going to live, to 85 or 95, then maybe that it would be a concern. But the average lifespan nowadays, what would it be? Are there really that many people that are well into those very senior years? And that could be, the reason that they put it at between 60 and 70, thinking that most people would not live beyond, maybe their 70s or into their 80s. I don't know for a fact. I don't have that solid research, but I just know generally what the span is.
Ms. Maasi for that, and there's nothing in here that deters anybody from updating it if it becomes an issue, if people start struggling to identify. So I don't think it's really a barrier or a deterrent in that way. And then if there are any legal changes, like a name change, I mean, they would just have to go and update it anyway so that they're compliant across the board. What does it take to apply for this the first time? Can it just be transferring over a Guam driver's license or a passport? For a Guam ID, does it, I was trying to look it up while we were talking.
I know that there's a Guam driver's license and ID application form. So anybody that would have to complete that at Reventax. I also want to mention when you're talking about people updating, we also have to remember that many people well into their 70s are still driving. So the option to get an ID card is, assuming that there are those people that don't have driver's license or just want to have an ID. So it's the allowance is there, but whether everybody will avail of it over a driver's license, I know, some people that are upwards of 80 or in their early 80s who are still driving. So, it's really just an option for convenience. Yes.
That is true. I've known quite a few spry 80-plus-year-olds that are still driving. So that is very true. So, I think the benefits are very strong. Like I said, Manamco Life is unfortunately filled with all kinds of paperwork already. So if we can simplify one portion of it for them, I think it can provide some good benefits. And they do still have the option to go in and update anything if they so choose to, or feel that they need to, because of any reason. So, Sejus Masi, Mr. Chair, for letting me ask a couple questions and make a comment.
All right, and when you were talking about Senator Kelly about the time span between ID cards, the only one that complies is number one, the real ID card and your passport. And on the military side, there is a time limit that once you reach age 65, we got to renew our military ID card, our retired military ID card. Okay, Senator Therese, do you have any questions, ma'am, you'd like to pose on the author or make any comments to the bill?
No, I support the bill. Especially if there are no objections from those who are actually using the ID, like banks or whoever is allowing use of that ID. If they have no objections, then by all means, I have no objections. So I just, hope they don't change their mind later, right? And then we have to redo something. So hopefully they've looked at this and they're aware that the IDs will not be renewing and they're good with it. And that's great. So it's a good convenience for the Manamco. Mr. Chair.
Right. Thank you, Senator Therese. And the reason why that was mentioned, Senator Torres brought up about the bank, because I was with my mother when we went into Bank of Guam, of all places, Bank of Guam, right? And they told her, says the new law said it expired. That's the reason why she had to go get a new Guam ID. And I didn't think that was acceptable. She's now 84 years old. Now what she needs to do, go back in? Ridiculous. Senator Tello, do you have any comments or statements you'd like to make or questions to the author?
Well, thank you, Mr. Chair. Well, first, I totally support this legislation. I think when I was in the 30th Guam legislature, I actually introduced a bill that passed called, for seniors to go to the front of the line. And actually, I set that bill for at 65, but some of the senators said, no, we have to follow the senior citizen guidelines for Guam, which is 55. And but I didn't want to argue it because they all said, no, it's got to be 55. So I authored that bill to allow for them to go to the front of the line. And I definitely support this bill moving forward. The only thing, Senator Torres, is how do you get our Manamco from stop losing their IDs or losing their documents? Because my father, I think in 1 year, he's lost his ID card maybe about 3 times, so once they get this ID in their hand, it's just finding ways they don't lose it. That's one of the biggest issues. But this is really good because I would rather have him lose a simple ID card than having to carry around his passport. That's a lot, much more difficult, to try and replace a passport. And a lot of times Manamco do, they carry around their passport and they could lose it. And that's a real important identification, So I really greatly support this legislation. And yes, it'll be my father's birthday present today. I can go to him today and say, hey, guess what? You don't have to do it. I know what he's going to say. He's going to say, well, can we do that with the driver's license? Because my father still drives, believe it or not, up to this day. He's got a convertible sports car Miata that he drives. So he's going to probably want that. I'm going, no, just an ID card, Dad. And it's perfect because it complies. It's not having to deal with anything on the federal side. So thank you so much for the opportunity and for this legislation. I'm in full support of it. Thank you. Thank you, Mr. Chair.
All right. Thank you, Senator Tello. And Senator Torres, do you have any closing statements for Bill 378, ma'am?
No closing statements, just Sejus Masi, everybody. I'm glad that, this is the feel-good bill of the day.
All right. Thank you, ma'am. There being no other individuals to testify for or against this bill, the committee will continue to receive testimony for the next few days. We keep it short because everybody would love to see this pass that I can see. And that please submit the testimony to the mailroom of the Guam Congress. to the mailroom of the Guam Legislature in the Guam Congress Building, or through email at senatorjoessanaugustin@gmail.com. And again, I would like to thank everyone for attending the public hearing and for providing feedback and suggestions. The public hearing on Bill 378-35 LS has been concluded. It is now 10:52. The public hearing for both bills is now adjourned. Please have a nice day and all be safe. Take care. Bye-bye.